Well, good afternoon, everyone, and I hope everyone had an enjoyable lunch. We're going to talk this afternoon in our first afternoon session regarding global trends in securities litigation. We've heard a lot about consumer, we've heard a lot about antitrust, but it's time to hear about securities litigation. And we have with us really a distinguished panel. We'll start with Mark Solomon, all the way to my right. Mark is a founding partner of Robbins, Geller, Rudman, Dowd, of their San Diego office. He leads his international litigation practice. Over the last 27 years, he has regularly represented the United States and United Kingdom-based pension funds and asset managers in class and non-class securities litigation in federal and state courts throughout the United States. Sitting next to Mark is Dr. Vinita Juneja. Dr. Vinita Juneja chiefly directs matters involving securities, finance, and valuation disputes, and regulatory investigations. She is chair of NERA's Global White-Collar Investigations and Enforcement Practice, and was formerly chair of NERA's Global Securities and Finance Practice. And like an angel from above, looking over us, is Jeff Lubitz. Jeff is the head of ISS's Securities Class Actions Services, LLC, a wholly owned subsidiary of Institutional Shareholder Services, focused on delivering critical asset recovery solutions to financial institutions and professional services firms across the globe. So thank you, everyone, for coming, and thank you to the panel. And so we're going to talk about today the global trends in securities litigation. Just like every other litigation here and every other form of litigation, we're all, whether you're in the US, whether you're not in the United States, we are all being impacted by globalization and basically by the clashing systems that are created throughout the world in different regulatory and legal systems throughout the world, and we're all kind of scratching our heads trying to figure out how to make sense of it all. And so I want to talk first to the panel and raise the issue regarding the international reach of US securities litigations. Specifically, when you have a case in the United States that involves a international issuer, or there's some international nexus to the claim, and how do you deal with those issues, and how do you grapple with those issues? And so that's really going to be the first focus of discussion. I personally was involved in the Petrobras securities class action, which settled for $3 billion, and there was a Brazilian oil company, and they issued shares not only in Brazil, they issued them in the United States, and they also issued bonds throughout the entire world. And there's a lot of questions dealing with damages, dealing with jurisdictions, and how do you deal with this behemoth of a case, and that really a lot of the folks here are dealing with. So I'll turn it over first to Mark and get your experience in how these cases, whether it's Petrobras, whether it's some of the other cases involving foreign issuers, how they impact, how they cause confusion potentially, how they cause complications, and how we deal with them. So Mark, take it away, please.
Good afternoon, everybody. It used to be easy in the US before 2010 to deal with situations where fraud had been committed and the securities were trading on different exchanges throughout the world. It used to be that so long as they traded in the US, you could bring in all your other claims and have them all litigated under one roof. In 2010, the late Justice Anton Scalia led a majority decision in a case called Morris versus National Australia Bank, in which he overturned over 40 years of jurisprudence and said, in fact, you have to have securities that trade in the US, or you have to transact in the US in order to find your way into a US court. And if you traded securities on other exchanges, go look for your remedies there. The impact of that has been profound. At the time, I had a case that was in settlement negotiations, and it was heading towards around a $200 million settlement. The news came down, and the next day, the settlement value dropped to under 10 million. So it had an immediate impact on me, drove me out of my mind. I couldn't understand why it ever got to the Supreme Court, why with a wonderful jurisdiction like Australia, some entrepreneurial lawyers hadn't managed to bring the case there and avoid the impact. Having said that, if you look at the US Supreme Court now, it's just a matter of time, probably, before a judgment just like Scalia's was going to come down. Our initial reaction was to sort of not believe it or try to do anything we could to avoid it, and we got into fairly esoteric analyses. But the bottom line is, it is what it is. If you've got a security that trades on an exchange out of the United States, you're going to have great difficulty finding a home in the US to bring the claim. You could bring supplemental jurisdiction, assuming you had an American case with securities that traded in the States. You could try and persuade the judge that the law of the other jurisdiction is sufficiently clear that he can adopt that and enforce it. If it's a non-English jurisdiction, then it's going to be more difficult. But even if it's an English jurisdiction or a jurisdiction that speaks English, you're still going to have problems depending on what courtroom you're in, what circuit you're in. So bottom line is, it became more difficult, and a lot of people, perhaps in this room, have profited from that because it led to a huge effort to try to find ways into courts in other countries and to try and find ways to persuade legislators in other countries to reform, to allow some measure of justice. That experiment is continuing. I think that all of you guys in the audience are very brave, swimming against the tide, trying to drive a square pole into a round hole quite often, because securities litigation that benefits from the class action mechanism requires a number of things to really be robust. It requires fraud on the market analysis of damages. It requires quite often contingency representation. We don't have a funder model in the States. The lawyers fund their own cases. Juries are very important. I've noticed that outside of the US, you don't get jury trials in many jurisdictions for civil claims, certainly not for securities fraud cases. And so you have to have both the ability to persuade outside of the US, you have to have the ability to persuade a very wary audience, very conservative audiences typically, and as a result, it appears to me that only the very starkest frauds are prosecuted civilly outside of the USA, with the exception perhaps of Australia, where the standard for liability has historically been strict liability, and as a result, claims there are relatively easy to prove. Having said that, and you'll hear later on, Australia's in a mess now because it's messing around with funders. It's trying to move towards a contingency model. It's moving towards a liability model that includes negligence, which apparently scares some practitioners. From an American point of view, we have to prove fraud, so if you only have to prove negligence, you're probably in a good place. So just to conclude my opening remarks, I am very respectful of all of the efforts in all of the other jurisdictions to try and bring these claims, but the bottom line is the center of gravity is in the USA. There are more cases filed in the USA every year than there are in the rest of the world every 10 years, pretty much.
Thanks so much, Mark. And there have been, as you mentioned, a number of efforts, despite Morrison, to find a way to prosecute claims under supplemental jurisdiction where you can actually, you have a U.S. claim and you'll try to apply. It's been done in the Perigo case under Israeli law. In the BP case, we actually got a court. Mark's from my firm got a court to apply UK law. And that's really has been the first resort for our firm, is to try to really kind of shoehorn in, even though Morrison says the US law doesn't apply to these claims, can we convince a court to apply a foreign law? And we've had some success with it. I wouldn't call it a deluge, but it's certainly been some modest success in getting that done. Jeff, what are you seeing as far as the foreign component of US securities litigation and how that's impacting your work?
Yeah, thanks, Jeremy, and thanks for having me. So I would agree with Mark in that certainly the Morrison decision a decade or so ago has brought about some barriers for institutional investors or any investors. And we at ISS represent institutional investors, and our goals are to maximize recoveries for institutional investors, pension funds around the globe. And as Mark said, there's a vast number of cases, more cases in the US than there are outside the US in a decade. And that's absolutely accurate. One trend that we're seeing here at ISS, and it's a positive for investors, is that there are a number of foreign companies that trade as ADRs in the United States that are facing or have faced securities class actions. And there's been a number of successful instances. Jeremy, your firm litigated and brought a tremendous victory for investors with Petrobras. So that was a $3 billion settlement in 2018. And the common trend with what I'm about to say is that litigation typically settles in the US, but it remains active overseas. So for example, there's still arbitration issues in case and litigation against Petrobras in Brazil. If we look at BHP and Vale, which were 50% stakeholders in a Brazilian dam that exploded and brought about egregious ESG issues to the local community, both of those companies settled their litigation in the United States, BHP for $50 million, Vale for $25 million, but both have litigation open, Vale in Brazil and BHP in Australia. And we've seen other successes with Chinese companies. Recently, Luckin Coffee settled for $175 million. Alibaba from a few years ago had two different settlements, one for $250 million in federal court and $75 million in US state court. So I think the common theme is, for now at least, with litigation being incredibly slow and uncharted waters in a lot of countries, your greatest success is going to be in the United States if you're fortunate enough to have these foreign non-US companies trade as ADRs in the US.
And why do you think that is, Jeff? I mean, when we to counsel our clients, often they'll say, well, maybe I could bring it in the home court if they're in the Netherlands, or maybe I could bring it in another jurisdiction. Why do I need to come to the United States, where we sometimes have to strain ourselves to get jurisdiction? Why is the U.S. Still the best forum to bring a claim, in your view?
Yeah, I think there's two primary reasons, and then there's probably another half a dozen that you can add to that. But primarily, I think one is there's no culture to settle outside of North America and Australia. These companies dig in the heels. They typically, there's no case, and the second reason would be there's no real case law, for lawyers and attorneys to kind of follow and navigate. And so we see a lot of frustration from our institutional clients with German companies like Volkswagen or Daimler. The diesel scandal with Volkswagen from years ago, our take is, we don't know when that's going to settle in Germany, yet they did settle in the United States for $48 million. So no culture for Volkswagen to even consider settling in Germany, and really no case law in a lot of these local jurisdictions.
Okay, great. Thanks, Jeff. So, Vinita, I remember working on the Fiat Dieselgate case in the Southern District of New York, and there was common stock traded both on the New York Stock Exchange and both in Italy, and there was a lot of debate amongst us and the defendants as to how much was actually traded in the U.S. Defendants were trying to say it was as small as possible, and therefore recoverable damages were as small as possible, and we were trying to argue that it was as large as possible, and that was really a key fundamental dynamic in the settlement discussion. So how did the international aspect of U.S. litigation, how does that impact your damages work that you're doing?
Sure. Just to give you some context for that, I've actually worked on over 1,000 U.S. securities class actions, but mostly for defendants, some for plaintiffs, and actually on the Petrobras cases that Jeremy mentioned, I worked for 25 different institutional investors and 14 complaints. So that's sort of part of the context. I also worked on the first Israeli securities class action 23 years ago, and spent a lot of my time on Canadian matters because I actually am a Canadian and an American, as well as cases in the Netherlands, Australia, and Japan. So that's the backdrop for answering your question. Now, a lot of the cases I do are actually cross-border cases, so there are claims in both Canada and the US, for example. What we're seeing is a couple, and another reason that this is all pretty important is that in terms of the US securities class actions, As of a couple of years ago, 20% of them were against foreign issuers, but now it's more like 30%. And if you are a foreign company, you're more likely to get a suit brought against you than a typical American company, just in terms of probabilities. We also see that, I have cases right now that are brought against Canadian companies and U.S. companies, Canadian companies in both the U.S. and in Canada. But I also have clients who are Canadian companies, but they're only being sued in the U.S. So it gets a little tricky in terms of, again, what shares are at issue. And the reason for that is that you know that there are shares outstanding, and there's a total number of shares outstanding for a foreign company. But you also know that the claims, because of Morrison, are for shares that are bought in the U.S. And it's harder to discern exactly what those shares are, because one of the things that we want to do is calculate aggregate damages. And for aggregate damages, you need to know not just what price people were buying shares at, but who was buying, how long they held, and when they sold. And that's not something you can always track. You can track certain components of that. For example, you know in the US when institutions are buying and when they're selling at the end of a quarter. You don't know it daily, but you can make some assumptions. However, what if that institution is domiciled in another country? Does that qualify as a share that was bought in the United States? What if it's domiciled in the United States? Does that necessarily mean that its transaction was in the United States? That's where it gets tricky. And so those are all the kinds of considerations that you have to take into account when you're doing this modeling and doing those calculations. You also have to really make sure you understand what data sources are available for trading and transactions in other countries, so that when you're doing that modeling, you don't ignore the fact that, for example, you may have in Switzerland certain kinds of information available about an issuer's transactions by certain kinds of institutions or holders, or that you may have different kinds of data available to you, again, in different countries. So all those things have to be taken into account. Recently, I had a case where the ADSs, which are what was being traded in the US, was what was at issue, but the filings, which were for this company, didn't talk about the ADSs. It mostly represented its data in terms of the common stock. The plaintiff's expert in that case didn't realize the distinction or the fact that there were 4 ADSs per common share. So when the damages were presented to us that he had calculated, they seemed really large. But when we looked carefully at the filings and we told our client, actually the damages are a quarter of what you just told us. And so that speedily, led to a resolution at a very low number. So those are the kinds of considerations that have to be taken into account. A couple other things. On the damage per share side of it, again, let's say I have cases, for example, that are brought in Canada and the US. So now, when you look at damage per share, what you're often looking at is what happens when some piece of information was revealed to the market. What happens to this let's say it's a stock, the stock's price. But you need to control for what was happening in the market and the industry on the same day. So which industry do you look at? Do you look at the Canadian industry or the American industry? It can be different, right? You also need to look at what happens when sometimes you'll have a holiday in one country and not in the other, but on a key date when you want to look at price impact. And then it becomes tricky because you might have slightly different results in terms of how much the impact is on the day before the holiday to the day after the holiday, because there's no trading on the holiday. But you may have a slightly different result when you look at the trading in the country where you had no holiday. And so those are, really the kinds of considerations that become very important, whether it's a foreign issuer that's being sued in the US or whether it's a case that's being brought in another country, but you also have trading in the US. And I think the last thing I would say is, in terms of class certification, it also is important to look closely at what kind of security it is, because you have different courts right now that are saying different things about, for example, over-the-counter securities and whether or not a class can be certified. So those are the kinds of distinctions that really need to be made and examined closely.
Great, thanks, Vinita. So, I mean, you raised a good point about the amount of foreign issuers and disproportionate amount of securities class actions that are focused on them. A big thing that we see in the industry is the Chinese issuers that have come to the U.S. and just really the rampant amount of Luckin Coffee is one example. The rampant amount of fraud that has been, uncovered over the past decade by these companies, and it's a great scheme that they have going on. The first thing they do is they just cook their books, and a lot of that, and really, it's not the SEC that's finding out how they're cooking the books. It's short sellers that go in and hire investigators and check out the actual operations of these companies. Sometimes it's Chinese online education companies, some of the most reputable companies in the world, and they find out actually by using web devices that actually the students are bots. They're actually not even students. And so what happens is you see fraud when they first come out an issue, and then they've got a whole other scheme going on where there is, if the company has some operating value, after they've made their IPO and reaped hundreds of millions of dollars, they then start to depress the value of the shares in the United States and publish fraudulently pessimistic financials, and they depress it, and they buy it back, the entire company, and they relist in Shanghai for about 4 times the value. And what's just discouraging for me to see is the SEC has seen this going on for about a decade. Only the Trump administration, as part of a general anti-globalization push, has started to do anything. And yet you see challenge after challenge brought in the United States. Some cases succeed, Luckin, where it's a rampant fraud. Other cases where it's pretty obvious there's been some misstatement aren't necessarily succeeding. So and my view is the Chinese government sees this going on. They see that the companies are ripping off Americans, and they're A-okay with it. They're just fine with their companies ripping off U.S. investors, and it's the U.S. investors that are left holding the bag. But I digress.
Jeremy, I'll just add, you're absolutely right. We actually wrote a white paper a couple of months ago on specifically Chinese companies facing securities litigation in the U.S. Because that is a significant rise and something that investors need to monitor and be aware of. Focus Media, Momo, other companies that have settled because of rampant fraud that have occurred. So absolutely a higher percentage of cases against ADRs versus U.S.-based companies. That's absolutely a trend we've seen over the last 12 to 24 months.
Yeah, and when we analyze cases, as Mark's firm does, to see, well, is this a case where there's likely fraud, is it not? We might look at the same factors, a U.S. company or a Chinese company, and you see sometimes surprise earnings miss by a large amount, or you'll see other factors, a write-down, impairment, and you look, well, it's a Chinese company? Okay, well, there's probably fraud going on. Maybe we'll get involved in this one. So with that said, so we do try in the first instance, as we discussed, to see if we can bring the securities and bring the action in the United States for a non-U.S. listed security. Often, and usually for an international company that doesn't list ADSs, that's not the case. And so, Mark, what do you do? What are you seeing now since Morrison as far as the trends outside of the U.S. and the kind of successes and failures in the various jurisdictions?
Well, you can rattle off, obviously, Fortis, Royal Bank of Scotland, Tesco, Volkswagen is ongoing in Germany. So there are litigation funders outside of the US. There are some funders within the US. There are some law firms working with other law firms outside of the US, all collaborating at least on some of these cases. Royal Bank of Scotland, as you know, was an offering claim. Not too terribly difficult, you wouldn't have thought, to prove your case, given the stark revelations. But it proved, I think, a very arduous, difficult, novel litigation for those involved. Lots of people frustrated, but ultimately it paid out. Tesco, fascinating. Tesco, again, caught with their pants down. You'd think pretty easy. What would be the complications in demonstrating that this is a case that deserves to be litigated successfully? And again, there have been payouts, but again, an arduous process in which People are so frightened of free riders that it's a statute of limitations game quite often. The cases develop very, very close and are announced very close to the 6-year limitations date. And then institutions in particular are persuaded to join. And if that's all done efficiently, then you can eliminate or mitigate the free rider issue. Tesco is just fascinating. Why on earth they would, and maybe somebody in the audience knows, why a month before the 6-year statute ran, they would allow a settlement to be disclosed is beyond me. But they did, and as a result, other groups quickly performed inside the 6-year statute, and those claims, I understand, have been paid out to the tune of, what, £193 million. So, you know, it can be done. I think in the UK, I think there is a deliberate avoidance on going to trial and appeal for fear on both sides as to what on earth might happen. Who knows what the judges would do? Historically, the judiciary here is very conservative. If you're old enough to remember The Politics of the Judiciary by John Griffith, then you're pretty old. But you know, he made it clear that the insidious conservatism of the judiciary here was a real break, a real impediment on achieving justice. I think it probably has changed, but I do also think, and I do see a number of women here and some people of color, but to be honest, it's a white man's game. It's a white man's game when it comes to funding. It's a white man's game when it comes to lawyers. It's a white man's game when it comes to judges, and there are no juries. So I think that, talk about culture, there's a very, very big difference in the cultures, obviously, and we're separated in the US and in the UK by a common language. When I first got to the States over 30 years ago, I was astonished by the class action process. I was absolutely astonished. I thought it was outrageous. I worked for Jones Day, Ravis and Pogue, known as Jones Day at Night, because they forced us to work day and night. You know, these class action lawyers would suddenly present these multi-$100-million claims out of nowhere, and I was astonished. But then I saw what Jones Day, Ravis and Pogue, or Jones Day and Night would do to these belligerent litigators, and they would bury them in documents, bury them in motions, bury them until they could bankrupt them, if they possibly could. And so I was persuaded that maybe the other side would be a good idea until I'd saved enough money to come back and practice in England. Still haven't saved enough money to come back and practice in England. And it was a revelation. It was, you could, you know, really write your own script. Is it the Wild West a little bit? Maybe. But there is an openness, there's an open court system in the US that I think should be the envy of the world. When Professor Paul Davis issued his report on issuer liability, which led to Section 90 in the UK, or the reforms to it, he did comment that there seems to be an association between deep capital markets and aggressive securities litigation. So he recognized that, but then he went on to say, well, we can't have the American experience, but with no analysis. There's never an analysis of this terrible American experience. McDonald's coffee, well, it was boiling, it went on the genitals, and it was reduced on appeal. What's the problem? So I really do think that instead of trying to force this square peg in the round hole, that other jurisdictions need to look at the US in a different light and stop this knee-jerk, not the American experience. That's the experience that delivers justice.
Thanks, Mark. And you know, I started also at a defense firm, Chadbourne and Park, and you know, lo and behold, I was working in the early 2000s on the opioid litigation against Purdue Pharma, which, you know, this 20 years later is still progressing. And my problem was I was always rooting for the plaintiffs. And so within a short order, they figured out I wasn't the right guy for the firm, and I was summarily fired. So here I am. But Jeff, what are you seeing on the international front as far as trends go, and as far as where the arrows are pointing in Europe and beyond?
Sure. So still a lot of frustration for institutional investors in the international markets. The litigation is still few and far between, And Mark hit on really the only two successes that have occurred in the United Kingdom: Royal Bank of Scotland and Tesco. Other than those two, we haven't seen any meaningful recoveries on behalf of investors. So the number of countries around the world is still very limited for investors to try and right a wrong, to try and recover lost assets from fraudulent activities that these publicly traded companies and or their executives are acting on. And so, we've seen some success in the Dutch markets, obviously in the Netherlands, where, there's been a handful of meaningful settlements and recovery amounts for investors. I think we see some good fortune coming with regard to Steinhoff, both a dual settlement in South Africa as well as in the Dutch markets. So I think there is a light at the end of the tunnel, so to speak, but it's not going to be easy. And the last statistic I'll just share is, we've done an analysis here at ISS where we look at the average settlement, the life cycle, the litigation life cycle, and we determine the life cycle from the initial complaint through the disbursement. It's great when a case settles. That's obviously critically important. But then on average, there's about another 16 to 18 months before those cases disperse back to harmed investors. And so the average life cycle that we've analyzed is about 4.85 years from complaint to disbursement, and that's US. And unfortunately, we see a much longer situation occurring overseas. And then the last point I'll actually make is also making it very difficult for investors to participate is the amount of participation, time, and energy and requirements in terms of documentation. Powers of attorney, do trustees have to sign actual documents? Are their names and information going to be public? Whereas in the US, it's much more private, and you're obviously participating after the case settles. But these are things that institutional investors truly worry about, and they're less likely to participate if there's more barriers to entry on these cases. And then that makes the amount of damages that plaintiffs are seeking to be lower. And so there's still a lot that needs to be, I don't know if corrected is the right verbiage, but a lot needs to continue to change and develop. But I will say, I believe we're headed in that right direction in a number of markets.
Thanks, Jeff. And Vinita, as far as calculating damages outside the United States in a non-US litigation, how does that work?
So I touched a little bit on that in talking about the foreign issuer cases. There is the issue of how you divide it, how you figure out how many shares are affected, and what you do if you have securities that trade on different exchanges in different countries, and how you account for the impact. But generally speaking, while there are different laws, obviously, about damages in different countries and different statutes, and those all have to be taken into account, the principles are somewhat the same, right? You're looking for material impact of some kind of information that was allegedly withheld or not disclosed. And, materiality in an economic sense is thinking about what's important. Well, the legal sense is what's important to a reasonable investor. But in an economic sense, that translates into some kind of information that's so important that investors are going to be moved to reevaluate and think about the value of that security. And so they're going to be moved to go into the markets and either buy or sell. And if enough investors do that, the price will change so much that it's going to be outside of the range of a change that you would have seen in the absence of any kind of news or information. So if there is some news or information on that day that is a disclosure of this allegedly undisclosed information, then that information would be material. And so that's the economic principle that we would look at. Now, that's not quite as formally stated in, for example, the American laws, but in Canada, it actually is embodied in some of the provincial laws, that you're looking for a price movement, and that's what defines materiality. So in that sense, often the conceptual groundwork is the same in different countries. However, I mentioned statutory limitations, and those are pretty critical. So for one example, in Canada, there is a liability limit of 5% of the market capitalization of the issuer. And that can be huge in terms of limiting what the damages are. And it's a different liability limit for individuals, but again, it can be huge in terms of capping the damages. So those kinds of things have to be taken into account. Another consideration is, I talked a bit earlier about the kind of data that's available, for example, on shares that are held and traded. It becomes really important to be very careful about what's out there so that what you are presenting to your client is defensible and accurate. I had one case where there was shareholdings data, and it was considerable, but it was cell phone photographs of written records from an Eastern European country. And, you know, it was hard to work with, but it was there. And if we hadn't used it, we would have had very, very different results. A couple of other considerations. In Australia, for example, the experts, the instructions to the experts are jointly settled on by both sides. So that affects the kind of work and analysis you're going to do. And then the last example I will give is in the Netherlands, the shareholders organization, which is sort of bringing the claims, is looking out for the rights of the shareholders that were allegedly hurt by the bad acts, but also for current shareholders. So that makes it very complicated. And we've had situations where our clients said, we need you to help us structure a settlement that is going to pay back the shareholders that were harmed, but not hurt the current shareholders. And, you know, it's like, well, if it's going out of into one pocket, it's going to have to come from another, right? So then the question was, yes, but how can we not have the company, you know, become bankrupt? Or how can we structure the settlement in such a way that it's, you know, warrants or something that is going to hurt the company less than some kind of direct payment? But what we had to explain to our clients was, ultimately, the markets are going to catch on to this, right? Like, it's not like you can somehow pay the past shareholders and not have some money that's coming from the companies. But you know, it did affect the structure of the settlement, even if we couldn't, you know, I think there is some tension in how you meet everybody's needs in those cases.
So Mark, there's a massive fraud that occurs outside of the shores of the United States. What jurisdictions do you want to be in? You can't be in the U.S.
I think, notwithstanding the frustrations of Australia, I think I'd give that another crack. It's still fluid. Negligence isn't such a terrible bar. Contingency fees are coming in. So yeah, I think I'd choose Australia. And again, Australia is a jurisdiction that has cases, obviously, given that strict liability used to be sufficient and now negligence, that are not the stark frauds that are required, I think, to materialize in the UK and probably in most other jurisdictions before there could be a class action or group remedy. So yeah, Australia, I think, is the answer.
Okay. Jeff, how about you?
I would completely agree with that. I think with all the issues that have occurred in Australia over the last 18 months or so, you know, in the US, you know, with Morrison, we've got the courts looking at various restrictions and changes potentially. You've had legislative changes that have taken place in Australia that is admittedly trying to, you know, limit shareholder rights, just to put it bluntly. And even with that, though, I do believe that's going to be your best avenue for success, even with the legislative regulatory restrictions that they're trying. You want to be in Australia if you're not, you know, in the United States or Canada.
Fantastic. And how about for the audience? Any questions? Charlie, please.
In which case you're elsewhere. But are there occasions where there's a dual listing, for example, in Germany and the New York Stock Exchange, where Morrison doesn't bite and US lawyers consider that they can go after all of those shares because of the listing in the US? And have you seen any examples of that?
So the answer is you will have to persuade the court to exercise supplemental jurisdiction over the non-US claims. If you purchased on a non-US exchange, it's going to be a non-US claim in federal court.
We were in the Perigo case, we were actually able to convince the court to take supplemental jurisdiction. It was dual listed in Israel and on the New York Stock Exchange. Israel has a law in their corporate law where they say if it's a dual listed security, we defer to the other jurisdiction, here, US law. So we said to the court, Israeli law is applying US law, you might as well just do it. All in the United States take supplemental jurisdiction, and the court agreed and actually certified for the first time since Morrison a class of New York Stock Exchange investors and Tel Aviv Stock Exchange investors. So it was cutting edge. I still think it's going to be the unique scenario, and it really does create a dual class of shareholders. One gets the added protections and added benefits of the U.S. litigation system, and the other does not, and it's simply unfair. And hopefully that'll be addressed in the coming decades. Any other questions? Okay, well, it's been a fantastic panel, both live and virtual, and thank you all for your participation.